Hi, my name is Micah Dodd. I'm the CTO of Swift Law North. Joining us here today is Aaron Swift, who's our CEO. How are you, Aaron?
Good, Mike. Thanks, and welcome Consumer Law 101 viewers.
Welcome, viewers. So today's lecture is the fifth one in our FCRA 101 series and is titled Suing Furnishers Under the FCRA, Secrets of the 1681s-2. So Aaron, where do we begin with this topic?
To start, let's just take a 10,000-foot view of what it means to even sue under the FCRA to begin with. So we start with a consumer, as we talked about, and go back to the definition video. So we have a consumer, there's a consumer reporting agency, there's a consumer report, and then there's an inaccuracy or something that's incomplete or wrong. So let's just assume all that has happened.
Okay.
And in this particular case, we are identifying claims against the furnisher, which is the person, again, going back to the definitions, the party that furnished the information. So 1681s-2 is the specific subsection of the Fair Credit Reporting Act that has what's called the private right of action. That's the part of the law that empowers consumers to sue on their own behalf for this wrongdoing. So the secrets of suing furnishers kind of starts with that backdrop of, again, the consumer has come to one of our professional affiliates, to me directly, or however, they've noticed this error in their credit report, and immediately, let's sue. But there are so many incredible and powerful steps that must take place that are crucial, not only to having a claim at all, but also the value of that claim. And that's what we kind of want to talk to today.
Okay, thank you. And now with that understanding, what else do our viewers need to know about the secrets of suing furnishers?
So, as I said, there are very important steps that have to take place. And this is the number one mistake that consumers make whenever they try to sue a furnisher, or even young attorneys, and please, I hope none of our viewers are doing this, but professionals that take an assignment of benefits, which is basically having a consumer assign the claim to them and then suing. I don't recommend that. But again, we're at this point where so many mistakes are made, and here is this critical distinction, Mike. If you want to sue a furnisher under the Fair Credit Reporting Act, they get essentially what we refer to as one free bite at the apple. Mm-hmm. To sue a furnisher, it's not just as simple as you see a credit report and there's an error. And you absolutely cannot immediately just sue that furnisher because that error occurred. First, you have to dispute that error and then allow for a 30-day investigation period. Mm-hmm. Even more critical, that dispute doesn't even go straight to the furnisher. The law requires that if you find an error, let's just say I have an error with a Capital One account. And again, I'm not picking on Capital One. It's just such an easy example throughout all of these video series. Mm-hmm. There's an error on a Capital One account. The client wants to sue. Nope, you can't sue right away. You have to dispute. Oh, well, what do? You have to dispute to the credit reporting agency, not directly to Capital One. And that is a secret. That's probably the most important secret here, and the fundamental mistake that is made. You will lose every time. Every federal judge who has had a case where the consumer either sued right away without disputing or disputed the wrong way has lost. So the secret is there is an incredible step that has to happen, which is the dispute. And it has to happen in a particular way by going to the CRA, not directly to the furnisher. Not many professionals know that. Even some lawyers make that mistake. Again, there's no claim. You cannot use the power of this law if you don't do it the right way. And I guess the other thing I would say is, if we kind of harken back to the first video series, the 10 FDCPA videos, there is a big distinction between disputing that can lead to FDCPA claims and disputing that can lead to FCRA claims.
Okay, can you clarify further the distinction between the dispute to the CRA and straight to the furnisher?
Yeah, so it's such a good question. And I'll then talk about these other types of disputes. So again, Capital One has an error in the report. Consumer comes to one of our affiliate partners. They recognize the error, and then they've come to us as part of our litigation program at Swift Law North. We know The consumer says, I read online, I'm a millionaire, this case is the best thing ever, I can sue, let's sue tomorrow. Well, again, we have to walk them through the process. We cannot sue tomorrow. We have to, again, to sue a furnisher, you have to give them a chance to investigate. So that dispute goes to the credit reporting agencies. And we're going to get into that dispute process in so much more detail in later videos. And you can do that in a number of ways. You can dispute by mail, phone, fax, online, but you have to do that first. And thus starts a 30-day process by which the CRA communicates the dispute to the furnisher does an investigation, allegedly, takes 30 days, and then the dispute results go to the consumer. At that point, if it's not fixed, then you can sue because you have ripened the claim by following that correct procedure. Yeah, you cannot just dispute straight to the furnisher and expect an FCRA claim. But remember back when we talked about the FDCPA, if you dispute directly to a furnisher and they don't mark it as disputed on your credit reports, that is an FDCPA violation if it's a third party. And that sounds kind of confusing, and I know it's a lot, but that distinction is critical, and we have more detailed videos on both series, the FDCPA and the FCRA, that talks about that in detail. But for purposes of this video, the secrets to suing a furnisher is that you have to give them one free bite at the apple by disputing. That dispute has to go to the CRA first, and then the dispute results, it has to not be fixed. That basically ripens the claim, and then the consumer can sue a furnisher. Otherwise, you're basically out of luck, or you'll be thrown out of court because you just didn't follow the statutory steps that are required.
Okay, great. And lastly, Aaron, can you tell our viewers how this all connects to the larger picture of credit repair?
Absolutely. As we've been banging over your head, viewers, litigation is the key to successful credit repair. Lawyer-backed, factual-based disputes are also the key, the solution, the future of real credit repair. These laws form the basis by which these parties are regulated. And so to be most successful in the dispute process, trying to repair, even if it leads to litigation or not, knowing these laws, understanding how they apply, knowing the secrets is really how you're not only going to set yourself apart from your competitors, you're going to get better client outcomes. You're going to get more deletions, more trade lines go away, more debt goes away. And if it doesn't work, you'll have partners who really want to then hold these companies to account, but fix the problem via litigation. And to do that, you have to understand these basics.
Okay, great. Thank you, Aaron. And as always, everyone, if you have any more questions, you can ask them in the weekly sessions or in the chats.
Thank you.